special congratulations. Just told me it's recording in progress. A special congratulations and welcome to Lou Varelli, who has just been appointed a new public member effective immediately for a term of 2 years. And that's well, we're assigning him more work in appreciation of all the work he's been doing for us in the past. So Lou, thank you and welcome officially to ACUS.
Well, thanks, Andy. I think you know how excited I am to be part of it. It's something I've really looked forward to and I'm grateful for it. So thank you.
Absolutely. Thank you. Okay, Matt, thanks for the time.
Thanks, Andy. I'll hand it over to Aaron then to get us going.
That sounds great. We can go. You can go ahead and put up Rule 300. Thank you all for coming. We're glad to have so much participation and activity and contributions to this project. It will be so much stronger with all of your thoughts and suggestions. We have a draft that was circulated late yesterday that has some of the comments that we have received, but we also want to give all of you a chance to weigh in. So we'll be doing that today. We've had 2 meetings so far regarding the qualifications section, and we absolutely welcome your feedback on that section and would request that you send that by email to us if you have any suggestions. Today, as Matt suggested, we have a full caseload starting at the proposed Rule 300 and going through to 319, at least as far as we can get today. Before we get started, I wanted to give Lou an opportunity to weigh in on this conduct section if he had any introduction or opening thoughts on it.
I thank you, Aaron. I think I would just say how thrilled I am about the amount of participation, because this was frankly, the section of the rules I was most concerned about, both for fear of being under-inclusive and over-inclusive. And I think I may have achieved both in this draft. So I encourage and I'm grateful for all the participation. I've been anxiously looking forward to this meeting to see how we can tighten these things up. I think you'll find that they are often an amalgamation of existing agency rules and the model rules of professional conduct, sort of as interpreted by me in an attempt to get the conversation started. So thank you, and I look forward to it. I should also add a particular thanks to George Cohen for all the work he did sort of collecting this information and providing guidance. I'm really grateful for him, moving us as far along as he did in advance.
It's wonderful to start the meeting with such a thorough draft, so many great ideas and so many comments in it. I think we're certainly starting from a great position. What I'd like to do is just start with the first rule we're looking at today, which is Rule 300 in general, and first open it up for comments to see if anybody has comments on sections A or B. There was a comment from George Cohen on section B. Does anyone care to weigh in on whether or not that section needs a change due to Rule 8.5B1, which I think is the jurisdiction choice of law section?
Yeah, it is. I mean, I can explain what my confusion was there. So what 8.5B1 says, and not all jurisdictions have adopted it, but what it says is that the applicable ethics rules in a disciplinary matter are the rules of the jurisdiction in which the tribunal is sitting, unless the rules of the tribunal apply otherwise. And so what this rule raised for me is this, if you're going to say, well, this is not intended to change anything under the applicable rules of conduct, then it's kind of a, dog chasing its tail kind of thing, right? How do you understand, if you're saying, well, it's the applicable rules that apply, but these are different rules in some respects. And so, so I think it could lead to confusion, not in these rules necessarily, but if there were a disciplinary action where 8.5b was the relevant rule. So maybe that's a overblown concern, but that was what was giving me some hesitation about it.
Do you think there's anything we could do to address that here?
Well, I mean,
Open that
maybe you
up
could
to
say,
anyone.
yeah, I mean, maybe you could say that it's the rules are intended to be consistent with the rules of professional conduct, but then you still have to figure out which are the applicable ones, which comes up later. But I'd have to think about it. I don't have an immediate solution.
Lou, do you have a suggestion?
You know, I mean, would just using the word limit help, or alternatively, because I think, and George raises an excellent point that I hadn't thought of, but one way to do this would be, because ostensibly if an agency adopted some version of these model rules, it would be triggering the unless the rules of the tribunal provide otherwise language in B1, right? So we could say not limit the applicable rules of conduct from the jurisdiction, and then so we're just creating a floor. Am I thinking of it right, George?
I think that could work.
I'm sorry, Lou, could you explain how you would want that constructed?
You got it. Limit
great.
lawyer is not nothing in these rules should be construed to limit lawyer representatives' obligations under the other applicable rules of conduct. Right. So they would be supplementary or additive, but not designed to substitute or constrain the model rules or the rules of the rules of the jurisdiction they're licensed in. If George thinks that's what I meant.
Yeah, I mean, I think there are. I mean, we'll talk about it later, but I think there are rules that are different from the model rules. Not conflicting necessarily, but they're phrased differently, or they have different components to them. So, so I don't know. I mean, was this really just designed to placate the ABA and their concerns about the rules, or what was the motivation behind it?
To trigger this conversation and make sure I didn't miss anything, right? So, because I think the larger point I was going to ask you about, George, and the committee is, I mean, effectively these rules are for, and I'm using non-lawyer, I would understand that term is something we're going to amend later, but for non-lawyer advocates, because under the Agency Practice Act, lawyers are in. Right. So, I mean, it seems like you could argue that any constraint on them, unless it's just added, it would be violative of the Agency Practice Act anyway, right? So it might be that we don't need any of these references. And that's why that's another thing I wanted to sort of talk about in the abstract or in the at a grander scale.
Lou, I don't see this language as going to qualifications. This is assuming the lawyer's in. The question is, where does the lawyer's obligations, where do they lie? And the answer is, in the first instance, they lie with these rules of the agency that's adopted our model rule here. And then to the extent that they're inconsistent with the rules of a particular where they're admitted to the bar, then if they impose additional requirements, then those additional requirements from the local bar would also apply. That's the way I read this, and I think the construed to limit does the trick. I don't think it needs any more.
Great. And those are the two sides of the coin I wanted to reconcile, right? And I think that's how I viewed it, Bill. I appreciate that. But I think George's comment, as put into practice by focusing on just limit, works from my perspective, but I obviously want the subcommittee's view here.
Any objections to the change? Hearing none, we'll assume that that's consistent. If anyone after this meeting thinks of anything that we did not cover or did not touch, please be in touch with us and let us know. This is going to be a working document for a while, so you're not limited to today's conversation. Moving on to comment 1. George had a question about a clause, and I'm wondering if deleting that clause would help resolve or tighten up that section. Or any other comments on?
Well, I don't think that should be taken out. I think George's comment lead to is the problem, because it might lead to something by somebody else. In other words, what the person did in what the ALJ did in a particular proceeding before, it might lead to some other disciplinary action by some other entity. But the idea is that the action, the attorney's participation in a particular proceeding before it, rather than imposing a disciplinary or other remedial measure impacting a lawyer's ability to serve as a representative in a separate proceeding. Wouldn't that do it, George?
Could you say that again, Bill? I'm sorry.
Think it's imposing as instead of
Yeah,
leading.
rather than imposing some disciplinary other real impacting lawyers. In other words, the idea is this is just dealing with this. It's not going to impose a sanction for something else, for something down the road.
Sure. Yeah. I mean, the agencies can't control what other courts or agencies are going to do. So that's fine.
Anyway, I took that this would cure George's concern, but I certainly like this clause generally in there.
Great. Any other comments to 1, or should we move to 2? In 2, Lou had a comment about whether the last 2 sentences were necessary. Does the committee have an opinion on that?
Well, I'll just, I mean, raise one question, and this goes to the question of consistency, and that is, later on when we get to confidentiality, there are some rules of mandatory disclosure here, where there aren't equivalent rules in the ABA version of the ethics rules, and so that would be an example of a potential inconsistency. And so we'd have to decide how we're going to resolve that.
Yeah, that's true. And I thought one easy way would be to make it consistent with the model rules. But the problem is individual state rules may still be inconsistent with even the ABA's model rules, much less ours. And so to say that they're not intended to be inconsistent, that's true, but they may very well be inconsistent. And one of the questions is what happens then? That's really not clear, I think, is the answer. Maybe the best thing is just to dump these 2 sentences, at least for the time being.
Does anybody have any objections to deleting this section?
No.
Okay. Well, let's go ahead. Any other comments on Rule 300? All right, let's move forward to 301. There were a number of comments on this section, and Lou's first comment may be the useful one to discuss, which is this rule necessary? Does anyone think that we don't need to define the scope of representation? Is this valuable?
I wonder about the title of the rule. I'm not sure that it's an accurate description of the substance of what's in it. This rule looks very much like Rule 1.2 of the model rules of professional conduct to me. And I can't remember off the top of my head what the title of that rule is, but it's not scope of representation.
It's scope of representation and allocation of authority between client and lawyer.
Yeah. It's
So that's not meant to be, I'm just chiming in, Jim. I think that's a fair point. I just, that's the longer title.
I think the substance is helpful in Rule 1.2 makes it clear that the client, or in our terminology here, the participant, makes decisions about the objectives of the representation, but the lawyer has input into the means by which those objectives will be achieved. I think it's useful guidance to the representative.
Do we think the longer title only with participant and representative instead of client and representative would be helpful?
Doesn't hurt.
Well, let's leave that in for now. Any other comments on A, B, or C?
I had a comment that I submitted yesterday that I don't see reflected here, which is that my recommendation was that the language of A be conformed to the language of Model Rule 1.2 of the Rules of Professional Conduct, to make clear the distinction that I just spoke about between the objectives of the representation and the means of achieving those objectives. I provided language.
So I think we have the change objectives of the representation in here.
Oh,
and-
yes, that's my change. Thank
okay.
you.
Yep. I think we were just gonna, any objections to that? We're just accepting that. It's a good change. In D, I think George had a comment about whether D was necessary. Or it might have just been part of that section. George, you want to explain your concerns?
Yeah, well, it's not a huge deal, but so basically, D is parallel to Rule 1.2D of the model rules, but then there is also kind of the rule for that's the equivalent of Rule 3.3 of the model rules. That's 310C, which also has to do with fraud. And so the reason I raise this is that, you know, the rules here are only about proceedings before a tribunal, whereas in the model rules, 1.2D is really about transactional fraud. You know, so I would be in favor of extending the rules to transactional fraud, but you know, the scope that we were given by the resolution and the complaints by the ABA were that they wanted to limit these rules to proceedings, and so if that's the case, my thought was that, well, the fraud prohibition is really covered by the 310C, and you don't need this. But you know, I don't see anything wrong with it inherently. But that was why I raised that issue.
Anyone else have thoughts on changing this section or keeping it as is? Lou?
I had not thought of this, so I'm grateful to George. I'm just thinking about it now. Are there activities that could be unlawful that would not fall within criminal or fraudulent that we might want to be warning or otherwise advising representatives about?
I think you could just say criminal. I mean, fraud is a crime, so I mean, it gets included in there if indeed it was ever an issue. But I think criminal is better than unlawful.
But 1.2D does list both, so that would be the argument for keeping it. I mean, for including fraudulent.
And what about like not complying with a subpoena, or that, I mean, destroying documents in advance before a subpoena, sort of like the equivalent of a litigation hold? That's not criminal, is it? Is it? It's sanctionable by contempt, but I don't think it's criminal. I don't know. That's what I'm asking.
Nina?
Well, at least in the Internal Revenue Code, there's both criminal and civil fraud. So I think that the word fraud, you know, you don't want to have a representative assist in civil fraud either. And so I think that fraud does have some meaning in some areas of law that's different from just criminal fraud.
Does anyone object to including criminal or fraudulent instead of unlawful? All right, that looks good. E is about solicitation. Oh, and there was a suggestion, the participant does not wish to be represented by that representative. Should we make that change and see how that looks? Other than represented by that representative being a little repetitive, any concerns with that language? Okay, great. Any other comments on any of these sections? Okay, let's move to the comments. Comment 1. George asked whether a lawyer could accept advance authorization from a client to settle a matter. Do we need to be that specific in this rule to address that scenario?
We could add a sentence that using a settlement as an example. So I would think maybe and I had not thought of this, so this is not by way of argument, but you could argue that a material change in the settlement amount would be enough to require new authorization, right? So could we give an example that sort of reflected that? So I think I could tell my representative settle for $1,000 and wouldn't have to tell them again when that offer arrived, right? I mean that sincerely as a question.
So I think the example would be a material change in the settlement amount. We could wordsmith that, I'm sure, after this. Would that example be helpful to resolving the concerns?
Yeah, I guess I was just reacting to the outset, not during the proceeding. That you know, that I don't think you can just sort of give a blanket authorization to settle something at the very beginning. But I guess there could be situations where that's possible. But that was my concern. But it's not a big deal.
And we might not need the word outset at all because the outset is during the proceeding.
True.
I didn't appreciate that part of the comment, George. Thank you.
I'm sorry, but I don't know why you'd want to take out at the outset. I mean, it is before the hearing takes place, right? Can the client representative, can the participant authorize the representative to take actions, specific actions? I mean, you might take specific action, advance to take specific actions, as opposed to do anything you want. And I don't, and I don't see anything in the ABA's 1.2a that would preclude authorizing somebody to make a settlement at the outset. I mean, it's just as long as it's clear that that's what's being done. But lawyers shall abide by a client's decisions concerning the objectives and shall consult to the means by which to be pursued. I mean, I don't see abide by a client's decision whether to settle a matter. If the client says you can settle it, that's the client's decision, isn't it? I don't see it. George, I look to you for this. I mean, I just.
Yeah, well, I understand what you're saying. I was just concerned that, the idea of a kind of a blanket authority to settle without even knowing what the terms are, I don't know. Maybe that is okay to do, but what I'm familiar with is that, the client has to give specific authorization to a particular settlement. But maybe that's not true. Maybe that's, I haven't researched it, but my understanding was you need express authority to settle generally. I have no problem with the other things, making tactical decisions and all that, giving that authority. That's not an issue. It was only the settlement question, and maybe it's not a big deal because most lawyers will understand that, you're going to get the client's permission before you settle anything. So I don't have a strong objection to it. But that was what I was concerned about.
That's why I put in specific action. That sort of makes clear that.
That's fine. And then I think you could take out the parenthetical.
Yeah, I think you should take out the parenthetical.
Excellent. Moving on to comment 2. Jim said this concept should be in the rule itself and not just a comment regarding the first section. Do others agree that it would be helpful to add that to the rule? And if so, does it need to be its own rule or should it be a separate one?
I've never really been quite clear in my own mind as to the relative distinctions between the rules and the comments. I recognize that supposedly the rule is the rule and the comments are only comments, but in practice, I've always thought of the comments as being pretty rule-like. So I mean, again, I look to Jim and George as to who know a lot more about ethics than I do, whether it makes a real difference.
The reason for my suggestion was that the model rule has this concept in the language of the rule itself, not merely in the comment. So I didn't like downgrading it to just part of the comment. I didn't put in the specific language, but if you look at model rule 1.2, it captures this concept in the text of the rule itself in a way that our text does not. I think the better practice is if something is important to the substance of the directive that you're given, it should be in the text of the rule and not in the comment. And I think that's particularly important if these rules are used by lay people. They're not going to bring to their reading of this a lawyer's understanding of what the comments mean and don't. They might just stop at the rule, and who could fault them for that?
Are there any objections to moving that into the rules? Hearing none. Would we separate out just that first section and then in the comments talk about the case of attorney representatives who should be able to read the comments and understand them? Is there any need to move more than just that first sentence?
My concern was limited to that.
Yeah. And I think that looks like it may fit in well with what we have in A already. Does that look all right to everyone? Excellent. All right, let's move to comment 3. And Stephanie raised an issue of whether the phrase authorization should be presumed for an attorney representative, and asked about non-lawyers and whether this makes sense. Anyone have an opinion one way or the other?
Yeah, I mean, I think my only question here, and this is carrying over from the previous working group where we've been having so much discussion about thinking about individuals who are not attorneys versus attorneys and how the rules apply. You know, it is a question about whether we're talking about what level of expertise and how do these rules also affect that? Because again, there are new attorneys who aren't going to have the same level of expertise as more experienced attorneys, and there may well be other authorized representatives who aren't attorneys who have more expertise and more familiarity with the subject matter. So to the extent that we're thinking about experience, the more that we're thinking about like experience and knowledge being what matters here, I again, that's why I question this language in the comment. And as I had said to Matt in my email and also in my comment here, like I sort of feel like I'm missing something about why the communication expectations would be different.
I agree with Stephanie. I think the distinction should be between levels of experience or not, and not the whether the person is an attorney or not.
What about removing that sentence and the following sentence, non-lawyer representatives, and just saying representatives without relevant experience or expertise should consult? Would that resolve the issue? And Lou, you had your hand up.
I was
Sorry.
going to say I agree with Stephanie. I understand where I think she's right. Really, that was what I'm thinking about when I'm writing that is the family member, sort of the least experienced possible person. And I don't think procedural deference works the same way there, but there's lots of stuff in between that has nothing to do with being a lawyer. So I was thinking of maybe going the other way and saying lawyers or other qualified representatives, whatever we wanted to do. But I think it might be easier just to do what you said, Aaron. So that's why I lowered my hand. But that's where that was the concern I had, was sort of at the lower end of the experience scale. I don't think procedural deference makes as much sense, but that's not limited to making attorneys the people we should defer to specifically.
Does that change work for everyone? Okay. Any comments on comment 4? Or anything else on this 301 scope of representation rule? All right, let's move to 302. We're making excellent progress, and I appreciate everybody's contributions. Anybody want to discuss the rule, either A, B, or C? We had a comment from George. I don't think dismissal by the participant should be limited to a clear lack of competence. I wasn't sure whether it was the lack of competence and we could just take out a clear, or if it was the relationship between the lack of competence and the dismissal by the representative that was a concern.
I was just saying that if you're talking about a participant dismissing a representative, usually a participant would be able to do that at any time for any reason. So they shouldn't have to demonstrate anything in terms of competence. So I think it was just, it was just a unfortunate parallelism, because I mean, it's okay to sort of limit the dismissal by the adjudicator for clear lack of competence, but I didn't think it made sense for the participants dismissal to be limited that way. That was my only point.
And is there a difference between lack of competence and clear lack of competence?
The same difference as erroneous and clearly erroneous.
Well, I don't know what Lou was thinking, but he can speak for himself. But I took it to mean that, at least as a practical matter, in the enforcement of the ethics rules, disciplinary authorities tend not to discipline lawyers for negligence only. They tend to either look for other violations or something that's really a more significant lack of competence. So I assume that that's what Lou was trying to get at. I think there's also a broader issue that I've raised several times in other rules, but this is the first time it shows up, which is the question of do we want to have a general rule on sanctions that apply to all of these rules, where we list all the possible sanctions, or do we want to have sanction provisions for individual rules, which is what this is? So I think it's more of a organizational and stylistic question, but this is the first time it comes up. But I have a number of comments later on where it comes up with later rules. So
does anybody have any thoughts on whether it would make sense to have a rule that address sanctions separately?
Well,
I
go ahead, Bill.
I noted that George's comments, and I think that probably is a good idea. And not knowing what's in the enforcement section, which is, I assume, where sanctions would go. And what I would say is, at least for the time being, we take all the sanctions that we see in these sections, and just put, brackets around it to identify the sanctions that we might want to put in the sanction section later. But let's look at them in terms of the language now, but just bracket them to go into a sanction section later, perhaps.
I wholeheartedly support that. I was going back and forth rule by rule, trying to figure out if I should be talking about the disciplinary aspects of it. And that's where I figured we would be over-inclusive and have this conversation. I think marking them for later consideration in the enforcement section is really helpful for me.
Excellent. Other thoughts on the comments? Good faith attempt, do people like that language? Or would reasonableness be a better standard? Are people comfortable leaving it as it is?
I mean, it seems to me good faith attempt is almost as subjective, and reasonableness is supposedly an objective standard. I certainly like the inclusion of facts and law as opposed to just relevant legal issues. In other words, I like that second part of what George said. I'm not sure whether I like sort of the subjective, the objective test, but that's the difference I saw between them.
For changing the end of the sentence to understand the relevant facts and law, would that replace legal issues and evidence in the case? Yeah, okay.
Well, I would actually prefer if there was an inclusion of investigation, not just understanding.
Understand the relevant legal issues and a reasonable inquiry into the facts and law.
To understand the relevant.
Yeah, why don't we take out a good faith attempt and say preparation and thoroughness include understanding the relevant legal issues and evidence and investigating the relevant facts and law.
Is everybody comfortable with that change? And have we lost you, Matt? You all right? Lou?
I understand where Bill's coming from. My concern is that's too high a bar for the family member. And Stephanie made it very clear that I'm too focused on that end of the spectrum, and I'm grateful for that. But that's what I worry, that if the standard is you have to understand the legal issues, then we lose a lot of the folks that at least I envisioned would be subject to the rules. I'm not defending good faith attempt. That it doesn't matter how we describe it, but I'm concerned this requires actual success.
But wouldn't this be in context of the person who it is? So the family member would be held to a different standard than a lawyer.
How about
That,
making that as another sentence, the following sentence? Aaron, you were the one who made the sentence. That was a great sentence, and it was, but it just seems like that'd be an explanation for the first sentence. The sufficiency of the preparation and thoroughness might depend upon
the experience or background of the representative.
Yeah.
Well, I don't, if you have an attorney who's inexperienced and is not doing their ethical duty to investigate, I don't want to say, well, they've got an out. I think it more has to do with the status, or the role, I guess that my word would be status. It's attorney, it's an unregulated representative of some sort, or it's a family member. I think that's why they were trying to go with that more subjective, or maybe the point is that reasonable is based on their status.
I like role or status. I would change might to may. Sufficiency of the preparation may depend on the status or role of the representative. Is everyone comfortable with that language?
I think that's a little vague. Says status or role, but you know, I think if we want to protect the non-lawyers, I think we should say that.
Would the example help? For example, a family member representative would be held to a different expectations than an attorney?
Yeah.
All right, any other thoughts on that comment? Any other thoughts on the other comments, 2 or 3? All right. If we're done with 302, we'll move on to 303. And always feel free to jump in or put your hand up. And if I'm going too quickly, but I don't want to go too slowly either. Diligence. There was a change made already, changing their representative to representing a participant. Any other comments about this section A? All right. B, similar change. Any comments on B or C? So in C, there was a question about whether this is a strict liability rule, and it does read, promptness requires a representative to meet all filing and other deadlines. Gosh, it'd be great if everyone met every deadline in a proceeding, but that I will tell you is not always the case. Is there a way we can maybe add a reasonableness or some other element to this?
Well, I had suggested adding reasonableness to A. Maybe if you do that, it carries over to C.
Where would we add that in A?
Well, I mean, so the ABA rule says a lawyer shall act with reasonable diligence and promptness in representing a client. So, I mean, I know Lou is trying to use more active verbs here, but so maybe it makes adding reasonableness awkward if you do that, but that's the way the ABA rule reads.
And then do we think that that reasonableness will apply to the rest of the rule, or do we need to put reasonableness more explicitly in the other rules?
I mean, I frankly think that promptness does require, as a strict liability matter, to meet filing and other deadlines. I mean, if these are imposed deadlines in the adjudication, then yeah, you got to do it. Now, do you always make it? Maybe not. And does that mean that the ALJ could say, hey, don't do that again? Or you do that again and there's going to be a problem. I mean, I think it is a strict liability. You are required to meet your deadlines, period.
I'm fine with that.
How does that jive with the Supreme Court constantly saying that unless Congress says that a deadline is clearly, in clear language, jurisdictional, it is just a claims processing rule and subject to equitable tolling? They've just come down with 2 years ago or a year and a half ago, they just came down with a unanimous case in tax that just said very clearly, we've been saying this to you over and over and over again. It's a claims processing rule.
Well, so it's not jurisdictional. I mean, okay,
That's right.
agree with that.
It's not jurisdictional, but it is a You know, so I'm just saying, how do you reconcile the strict liability with equitable tolling?
Well, I'd say strict liability can be equitably told. I mean, that's what equity is. But I think, you know, we're not talking about jurisdictional issues here. I mean, I think otherwise, if you just say, well, you know, deadlines are, you know, they're there, but you don't have to follow them. I mean, I think, yeah, you have to follow them. If there's a good reason why you didn't, then okay, then obviously you won't be sanctioned. But is it possibly subject to sanction? Yeah.
Rebuttable presumption. And most courts are going to have a rule that says if you need extension or you need more time, fine, but tell us before the deadline so we can keep things
Sure.
moving.
Of
So,
course.
all right. Anyone propose a change to this section, or are we comfortable with it? All right, let's look at D. So George says, this is different from Rule 1.4, comment 4, which says a lawyer should carry through to conclusion matters undertaken unless the relationship is terminated pursuant to Rule 1.16. Is there a change we could make to this that would perhaps be more consistent? Or are we not worried about being entirely consistent?
Well, I guess it would help me to maybe Lou could explain what he had in mind. Maybe I just wasn't understanding why the rule was written that way, because it reads as if, you know, well, even if you withdraw and you're allowed to withdraw, you still have more obligations to carry through to completion. So that I just didn't quite understand how that was supposed to work.
I have the same problem.
Okay, so all I meant to say, and I'm not sure I'm flipping between Rule 307 and all I meant to say was this rule effectively is not meant to change the withdrawal requirements, right? You can, if you withdraw, and therefore you're no longer representing. But if you don't withdraw or aren't terminated, I think adding the termination thing makes perfect sense. This is what diligence requires. Is that responsive, or am I missing something?
Well, then I don't think I would say notwithstanding a withdrawal. It sounds more like unless there's a withdrawal.
Maybe could we start with diligence, just take out the first section, diligence requires a representative to carry through, and then at the end say, unless the representative has withdrawn or been terminated.
But we could do that in a comment either way. Right, this is not meant to be, and meant to limit or otherwise change the requirements of Rule 307. And any or all of those things are fine by me.
See, any thoughts on whether it should be in the comment or the rule?
I think a comment would be fine. Comments are often used to cross-reference other rules. So
You can probably just put unless the representative has withdrawn or been terminated. And then we can fill in any appropriate sites or wordsmith that. All right, comments on subsection E. This is if the participant has diminished capacity. we don't want it to sound like a representative can just make decisions for the participant. Is there some fine tuning we could do of this language to tighten it? All right, not hearing any suggestions.
Well, you could try to just use the language of Rule 1.14.
That's certainly fine by me. I have to admit, I'm not an expert in this, George, is probably why, but I didn't really understand what normal client-lawyer relationship. That seems like a weird way to say it, but it's what the rule says. There's no question about that. I think I was just trying to avoid that phrase because it seemed awkward to me.
Yeah, I don't have a problem with changing the language, but yeah, I just think continue to represent the participants' interests makes it sound like Aaron was saying. It makes it sound like the representative just would decide what that interest is, and that's certainly not the thrust of Rule 1.14. So, and it wouldn't be client lawyer; it would be client representative. I mean, the participant representative. Yeah. And then, yeah.
Is everybody comfortable with that change? Okay.
Yeah, I'm just wondering if there is some way to provide the option or a mechanism for consulting others who might be better positioned to not represent the participants' interests, but to explain the participants' interests. Of course, consistent with the attorney-client relationship and sharing information. I'm not sure what that language would look like. Or what that consultation would look like.
Let's look at comment 2, and perhaps that could address, or we could supplement that, because it does talk about employing surrogate decision-making tools. Right. And maybe we could add a sentence about consulting appropriate resources. And for that comment too, would it be helpful, do you think, to add an example such as relevant government agencies?
Right, and I was mostly thinking about like ombuds programs and aging programs that have that ability.
So can we add a sentence to that comment 3 now? Do we think it would be helpful to add a sentence that representatives are authorized to consult appropriate resources?
Aaron, are you suggesting rewriting the first sentence in now comment 3, or adding a new sentence in front of that sentence?
I was suggesting adding a sentence at the end. So the representative may consult appropriate resources And I guess I would end it there, but my question is, then you bring up, do they have the authority to do that, and potentially other issues that might make that not practical? Lou,
How
you
about-
look like you have a thought.
Yeah, I'm not certain it's helpful, but I'm wondering if this could go at the end of the second sentence in the current draft. So it in that sentence, protective action could also include employing surrogate decision-making tools like durable powers of attorney, comma, or consulting appropriate resources. I would love to have a such as or a, but I don't, this is where my expertise runs out. Some clause explaining a little bit more what we mean by appropriate resources. Because I do think that last sentence is summative. That last sentence is best at the end.
I agree. So we could probably work on coming up with an example for that.
I will duly warn the subcommittee that right now I have no idea what to put in that list of 5 capital X's. So if anybody's got any ideas, I encourage you to chime in. I'm certain there's something useful to be put in there. I just don't know what it is.
Agencies for aging.
Aging, long-term care,
Mhm,
adult protection.
mhm.
Yeah, I knew this would work. Great. And thank you all very much. I think that's a great addition. That's really helpful to me.
Excellent. Any other proposed changes with this rule? 303. All right, let's move on to 304, communication. Are people comfortable with using reasonably necessary here? Or reasonably able, perhaps? Any concerns about that change? All right. The comments. Communication from a representative to the represented participant should be done in language that the participant is able to understand, or in a language. To some extent, those are two different things. We could say in a language using language that the participant is able to understand.
Yeah, I think that you need to have both of those. Maybe saying in using terms and a language.
Yeah, that's good. That gets at both. Excellent. Moving on to 305.
Wait,
Yep.
can I just,
Please.
going back to the change, I don't think reasonably able is the right way to say it, because I think the 1.4b is focusing on the reasonableness of the, it says a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions. So I think the client or the participant should be able to make informed decisions. I think the reasonableness has to do with the degree of the communication.
Yep, you're correct. Would reasonably communicate.
Yeah.
Thank you. That's good. All right, anything else on communication? All right, 305, organization as a client. Perhaps it should be organization as a participant. That was one of George's suggestions. And then there's also a question about whether this should be here. Is this something that could be moved? Lou, do you have any thoughts on moving this potentially?
I defer to George's and the committee's judgment. I have no problem moving it. This was maybe the best example of over-inclusiveness by your reporter.
So
I didn't see any harm in it. I mean,
301 is fairly long, so this would help people find the rule, to be frankly. All right, so any other changes to this? If we're going to keep it, should we keep the rule as is? I'm not hearing an objection. What about the comment?
George, wouldn't it be accurate here if it said ultimate decision-making authority on behalf of the organization for purposes of this proceeding, for purposes of the proceeding?
Yeah, I guess it was, I was just concerned because there's, in the in securities law, there's a case that sort of talks about this ultimate decision-making authority, and that seems to be a reference to like the CEO of the company or something. And I don't think, you're not really talking, you're talking about the general counsel or someone who's assigned to work on this case. And so it was the ultimate authority that was hanging me up because of the way it's used in some case law.
You think putting for purposes of the proceeding at the end would cure your problem?
I think that helps, but I think it's the ultimate that's hanging me up. I don't know why decision-making authority itself is not good enough.
Okay.
So we could delete ultimate. Are people comfortable with these changes? And are there any other thoughts on 305? All right, let's move to 306. So this is confidentiality. And I had a question actually for Matt or Akis. Is there a preference for should versus shall generally in Akis recommendations?
Well, this is not a recommendation, but a model rules.
Thank
So
you, sorry.
I would keep that in mind. We tend to use shall if it's something that we believe in our recommendations that agencies must do, versus a should. It's something they should do given their other constraints.
So are people comfortable with should here? And that would be in A.
Why shouldn't it be shall? I mean, duty of confidentiality subject to exceptions that presumably are in B. It's not a should, it's shall. Isn't it?
Give it that.
I think I'm seeing agreement. Could we change it to shall? All right, anything else on A? I appreciate everybody sticking with us. We're making good progress, so thank you all. Let's look at B. And George says this is stronger than Rule 1.6, which uses may. Do we are we making the choice to have must instead of may?
I don't think we should.
Representative may disclose information.
Mhm.
Mhm. And do we want to narrow the disclosure to the responsible agency official?
Oh. I wouldn't think so. I mean,
In the case of suicide, the agency, I mean, time is of the essence. So a suicide threat, then you need to disclose it to not the agency official, but to a local law enforcement agency. I'm not sure that agency official, would cover that.
I agree.
Mhm.
That's fair, yeah.
Maybe you could say to the appropriate agency or an appropriate agency, or just not say anything, just that you can disclose that information.
I think that's the point. The point is this is a permission that it is an exception to A. It doesn't tell you where you do it. It's saying this is an exception to A.
And the grounds for the exceptions, we have 3. I think there was some wordsmithing of the third one that we've put in to enable a representative to respond to an accusation of wrongdoing by the represented participant against the representative in the proceeding. Anyone have any objection to that change? And then in 4, there was a question whether an exception would be to comply with existing law. Do we need to include agency regulations in there?
Well, yeah, I mean, that's, George, what is the ABA?
Whoop, you muted. We lost the end of that.
I said, what does the ABA model rule say?
It
The
says
equivalent.
law in the model rules, and it's not completely clear whether law includes regulations. I would imagine that the ABA would take the position it doesn't. And it's including it explicitly would be controversial, I think, with some ABA folks, but I was just raising it because that I think it is a question.
Well, I agree. That was my concern as well, is that I certainly don't want an agency to adopt a regulation saying whatever the ALJ tells you have to disclose, you have to disclose. I mean, that's and say that that's okay. Well, we could say comply with existing statute.
Yeah, I think statutes are covered.
Yeah, that's why I say law could be interpreted to include regulation. And that's why I was just going to say statute rather than law.
So,
But what about court decisions?
yeah, 'cause court orders in the rule, right? That's why I'm confused as to why regulation wouldn't be obvious, but clearly it isn't. I'm not quibbling with that. That doesn't, I mean, a regulation is no less legally binding than a statute. I think I'm in a safe place to say that, right? At an ACUS meeting.
Yeah,
right.
I agree.
As is an ALJ's order.
Well, that's the point, though. I mean, I don't think we want to give the ALJ the authority to tell somebody they have to reveal confidential information. And I don't think we ought to allow an agency regulation to say that either. If Congress does it, that's the source of the privilege in the first place. Well, there's maybe a constitutional aspect to it as well, but court orders and statutes is what I'd accept.
Yeah, I would just think that the remedy for having an ALJ tell you to disclose something that you aren't required to under law would be to seek judicial review of the ALJ decision, right? I mean, because a court could do the same thing. They could order you to disclose a trade secret, and you would say, "I'm appealing that decision because it's a trade secret." I don't care. I'm just wondering. I'm just curious. I'm just learning now. It doesn't really matter. In the interest of time, I should demur. But do we want the representative making that decision about whether they have to comply with an ALJ's order?
Well, if it's an order to disclose confidential information, it's otherwise confidential, I'd say no, I don't want an ALJ to do that. If the agency thinks it's that important, let them go to court.
Are people comfortable with court orders or statutes?
Well, I will just register one issue that I have, which if you're going to make it court orders or statutes, then I think it should be must for that rather than may. But that's an issue I have with the ABA rule as well. But it seems kind of awkward to sort of say you're allowed to disclose things you're legally required to disclose.
Well, I again, this is an exception to A. It's not telling you what you have to do. It's telling you what A doesn't apply to. So whether you must or may must or permitted, whether you must do it or whether it's up to your discretion is not what the may means. It's just that B is an exception to A, period. That's all it is. It doesn't decide whether or not you have to disclose it or not. Whether something's mandatory or not depends on, if it's a court order that says you have to do it, then you have to do it.
So if we leave the
wait, I just noticed something. A says except as required by subsection B. And it should be except as provided by subsection B. And then we could say, the prohibition in subsection A does not apply if disclosure is necessary too.
I actually liked the may in there because it lets you decide whether you want to appeal a court order or even challenge the statute based on constitutional concerns. It says you may disclose if you don't want to appeal or you don't think there's any problem with this, but it doesn't force you to accept the court order or what the statute says. It allows you to appeal it.
The way we have it now, the prohibition in subsection A does not apply, would mean you're not.
You don't have any discretion. You have to, if it's necessary to comply with existing court orders, then you give up your right to appeal.
Well,
or maybe I'm not reading that, but I'm just saying that's how I saw may in there.
Well, you would not be giving it up under this thing if you were challenging the constitutionality, lawfulness of the court order or statute, constitutionality of the statute or the lawfulness of the court order. All this says is that the prohibition in A doesn't apply. So now whether you have to comply with an illegal court order, right, if the court order is otherwise illegal, then you can still appeal it. It's just that the prohibition of A is not your safe harbor.
Well, let me just say that the way the ABA 1.6 rule is written is it says except as permitted by subsection B, and then it would say we would go back to a representative may disclose. That's the way the ABA rule reads.
I'm happy with that as long as it doesn't create a problem with comply with the court order. I mean, it just, I mean, either way is fine.
All right, so we're back to this version. Let's look at comment 2. Is that something that can be deleted and is now covered in R4 with court orders and statutes?
Yeah, I definitely think it should be deleted because I do not want anybody in the agency to be able to order somebody to disclose something. I'm curious. I order you to disclose it.
All right, any concerns about any of the parts of 306 or additional discussion?
Can I just ask I didn't see this before, but in subsection B4, the word existing, is that necessary?
Good catch.
Great. Anything else on 306? Let's move forward to 307. Withdrawal and termination of representation. We'll start with A. And George asked whether we want to consider mandatory withdrawal for reasons such as those listed in Rule 1.16A. And I wonder if that is to some extent or could be included in our comment 1, which has examples of good cause for withdrawal.
I think it's an excellent point by George. I wonder if the last line of the comment, maybe with a little wordsmithing, could do the trick, or if it's important enough to move up.
George, do you think this is something we could cover in the comment?
You could, but yeah, it's just that the lawyers would be familiar with the idea of mandatory withdrawal for the reasons that I listed here. But it's, maybe it's good enough to put it in the comment.
I mean, we could have a separate mandatory withdrawal, a new A, if we thought that would be helpful. And perhaps it would be helpful to the non-lawyers who maybe wouldn't be as familiar with those reasons.
I would suggest it be put in the rule itself.
Lou, do you want us to finalize the language of this, or do you want to look at the model rule and come up with something?
If the subcommittee would rather me do that, that's fine. But while we're sitting here, as you probably know my answer, right? If we could benefit from the collective wisdom of everybody and wrap this up now, that would be great. I think we may be as simple as listing the things in George's comment, but maybe I'm being too myopic.
So that would
you could just copy rule 1.6A, except you have the word Smith a little bit under sub 4 and change the word client and lawyer to representative and participant, but that's just.
I think we just say violation of law, right? Because most of the
You could say
representatives
these
don't have any
rules
rules of
are-
professional conduct.
Thank you very much. How is this looking to everyone?
I'm just wondering.
Is it too long?
No, it's not that it's too long. The very last of the very last one, in using representative service to commit or further a crime or fraud. I mean, that's obviously mainly aimed at transactional stuff in the model rules. And I'm just trying to figure out whether it would ever be, applicable in a particular agency adjudication. I mean, it's difficult for me to think of a situation whether it would be or not, but
Well, this goes back to the discussion we were having about 1.2D and the rule, things like subpoenas or whatever, the examples we were talking about before. I would say that this 1.16, this now, the last part has not been in 1.16. This is just a new adoption by the ABA that just came out. And it was in response to concerns over money laundering and knowing your client kinds of things. So it actually now includes that there's a duty to assess the facts to determine whether you're allowed to take the representation in the first place. And the concern was over money laundering and similar kinds of things. And they decided to put that in Rule 1.16. So that's this is now a new version of it. And so no state has adopted this last part about crime or fraud, although it's...
why don't we just leave off this last one then if it's in that circumstance.
And we might be able to sort of solve, at least accommodate that idea if we delete these rules or in the second line, because I don't think we want to say you must withdraw for violating one of the model rules. Right? If you don't display appropriate candor to the tribunal, we're not necessarily requiring withdrawal, right?
If you're going to keep that last, are you going to delete it or keep it, that last clause?
Sounded like
just delete.
Yeah, it sounded like we were leaning towards delete.
Okay,
Is everyone comfortable with the new A? All right, so now our new B has to do with permissive withdrawal. Yes,
I'm sorry, could I go back to A for a second? I mean,
of
so
course.
one of the reasons that the Rule 1.16 says must withdraw for violation of the rules is conflicts of interest. That's what one of the things that they have in mind there. And so, you know, I don't think they're thinking about, well, every time I kind of miss a deadline or something, I have to automatically withdraw. So I think they're thinking about things like conflicts of interest. So, which is not, you could say, not a violation of law if it's defined as statutory, but
don't we have that covered somewhere else? I have some memory of
well, conflicts are covered somewhere else. That's true.
right. Yeah, that's what I thought. So we could still just limit this to violation of law.
Because theoretically, a client could waive a conflict, right? Or a participant could waive a conflict.
Right. Well, then it's not in violation of the rules.
Right. Right. So we could include a cross reference to 317 if conflicts. Clearly hadn't thought of that. So that's an excellent point.
But if you say result in, okay. Well, does 317 provide for the, well, don't you have to say in the absence of a waiver will result in a conflict? Will result in a conflict in the absence of a waiver or something?
Well, I think it's in that rule. But I think it's actually broader. I mean, the ABA rule is broader than just conflicts. I think, you know, if you look at the comment, it says what they're interested in is situations where the client is asking the lawyer to do something that would violate a rule. So, you know, they use the language will result in a violation, but I think it's situations that would include conflicts or fraud or other kind of deliberate violation of the rule that the client or here participant would be asking the representative to do. So that's what they have in mind.
That's going to take too long to work out in terms of the language. I'd hand this over to Matt or Lou or Aaron, anybody but us. I think George's comment and it's a good one, and maybe we should include this what's meant in the comments of the ABA rule.
Yeah, that's fine.
But I don't think we can wordsmith that here today.
It seems like perhaps this is something that could be addressed in the comment to this rule with a reference to 317. But we'll let Lou sort through that. All right,
I'm sorry. I heard I understood what Bill meant, and I'm not trying to throw this back on the committee. But what about something like will result in a violation of the law or of a rule in such a way as to materially affect the ability of the representative to adequately represent the participants, something like that. So try to define a subset of rules that are getting at sort of not competence, but the ability to serve as a a good faith representative and not meeting a deadline. Conflict, and then we could put in the comment that a conflict of interest would be that kind of rule.
But I think that what George was saying is that they were also talking about where it's the client who is making the lawyer do something to violate the rule. And that's the situation where the lawyer has to withdraw if the client is forcing him to violate the rules of professional responsibility. Whatever rule it is, diligence, promptness, if the client is forcing him to violate the rules, then the lawyer has to withdraw. And that's not what we're capturing here.
Right.
And that's the idea that needs to be communicated if we put that in here. And again, you know, maybe I could do it later this week, or Lou could, or somebody, but just not now. It's just going to take too much time, I think.
Yeah, right. Making notes too.
Well, I would recommend just right now, just using the language that's in 1.16a and then making a note that we might want to tinker with it.
Yeah, or put in the comments the explanation for
Of what it means,
what
sure.
we mean by that,
Sure.
and not including the last part of 1.6a, that part that we got rid of.
Right.
Yeah, these rules, I think, is what we had before.
These rules.
That's really helpful. Thank you. And thank you, Matt, for carrying all that water.
All right. Let's
Last thing.
no.
What's now the rules of professional conduct should violation of these rules.
All right. Anything else on A? We ready to talk about B? So in this one, representative needs to show good cause for the withdrawal, and the withdrawal will not adversely impact the participant's interest in the proceeding. It sounded like George thought perhaps we should mimic the rules in 1.16b a little closer.
Yeah, I mean, I just thought we should at least talk about it or think about it, whether, because this is a different standard than what's in 1.16b, and it may be that I don't know, Lou, if you were trying to kind of incorporate the idea that, well, since this is before some kind of tribunal and the tribunal could order the representative to stay in there, maybe that's what you had in mind, but it's just not the way that the ABA rule is written.
Right. I was worried about sort of the non-lawyer not feeling an obligation to carry through, and just sort of picking up and leaving. and maybe we want to allow that.
Well, if the withdrawal would not adversely impact the participant's interest in the proceeding, I mean,
Right.
that's, I mean, isn't there some requirement that absent one of the absent good cause, isn't there a sort of a need for approval by the agency adjudicator? I mean,
Part C has it, but it carries through the good cause requirement.
well, no, let me rephrase it. I mean, in the ABA rules, they're talking about generally you're representing the client, right? You're not even in a proceeding, you know. So it's between you and the client whether you withdraw, all right? Generally speaking. But if you're in the middle of a hearing, right? I mean, if you're in the middle of a trial, an attorney can't just withdraw, right? Even with the agreement of the client without approval of the court. I mean, that because it screws up the whole proceeding. And that's what I'm trying to get across here is that where is that taken account of? Am I not right on this, George? I mean,
No, that's correct. And that's what I thought Lou might have had in mind, you know, and so maybe it makes sense to sort of put C first, that, you know, that to emphasize that it's not a unilateral process here because it is a proceeding. And you're absolutely right, Bill, that if you're in a court proceeding, the court can sort of say, you got to stay in there. You can't just withdraw. So, so maybe we should just, since that's the only thing that we're talking about is representation in the proceeding, maybe we should just use that as the basic rule.
would that only be for good cause, or what? And actually, I think when he said up front, I mean, probably should come after the must withdraw. We're still talking about the may withdraw situation, but is it only when it's for good cause, or is it anytime?
Well, the way the ABA rule is written is you can withdraw if there's no adverse effect, and then but a court can order you to stay in if the court has a different view of it. So I mean, we can write it that you can make an application to withdraw, and we could sort of say that the adjudicator can decide to allow it for good cause or any, you know, if it doesn't impact the proceeding, but leave it within the discretion of the adjudicator.
So it sounds like we would make a change to what's now B. Representative must submit a written request to withdraw for good cause, or if the withdrawal will not adversely impact the participant.
Well, or the proceeding. I mean, maybe the participant would like to have this thing delayed indefinitely while he tries to find another lawyer, but maybe the government doesn't. You know, I mean, once you're in a proceeding, it's not just that the participants' interests that are at stake. Okay, affect the participant or proceeding.
And that's an or, so they don't need to show good cause or explain their reasoning in that scenario. Written requests must be included in the official record of the proceeding and served on the participant. No issues with that?
Yeah, I mean, I think the first sentence, to have to the responsible agency official should come, must submit to, or must submit a written request to the responsible agency official to withdraw for good cause. Rather than at the end, it just doesn't read very well, I thought.
So we'll just move the to the responsible agency official in the middle. Just
Yeah.
cut We're going to move that phrase, yeah, right there, and put it in the first line after submit a written request to, and then do your insert.
But I mean, should we just delete the rest of that sentence since it's the reasons are covered in paragraph C? And
Or
leave
we could
that
combine
same?
B and C into one.
I like having the sentence that's in C in there somewhere because it separates out the standard from the request. All right. It sets the standard for permissive withdrawal separately. And then I thought of C as substantive and B as procedural.
I think we could delete what is currently highlighted, which would keep B procedural and include the having it on the record.
Right. And then maybe flip B and C back, but I leave that, I defer.
Well, no, and then in C, and or the withdrawal will not adversely impact the participant's interest proceeding, participant's interest. What did we have in the language before? Because it's, yeah.
Yeah.
Terrific.
All right, so D, is everybody comfortable with A, B, and C as they
Should
stand?
we rewrite the beginning of C to say that the responsible agency official may allow withdrawal, since it's not really a unilateral withdrawal.
How about may permit and then just go to a representative to withdraw from representing? I think that flows well into D. Withdrawal will be allowed based on the participant's written consent and the approval of the responsible agency official. I don't think we had any comments on that before. And then E.
What if the participant doesn't give written consent in a situation where the attorney has shown good cause, or under A where he has to withdraw?
Does also in that provision solve the problem? Or no?
Well, that's saying that.
Can we scroll up a little bit? Thanks.
Yeah.
It sounds like we're not thinking somebody can withdraw just based on the participant's written consent.
Oh, I see what you mean.
Yeah,
So if the agency official says no,
they'll also be allowed. Okay, all right, I received.
All right, and then E, participant may terminate the representation at any time. subject to liability for any outstanding obligations of the participant to the representative. And then E is about soliciting a representative or soliciting someone who's not interested in being represented. And Stephanie had suggested that this be moved. And trying to figure out what's going on here. Is this trying to prevent harassment? Bill, did you have a comment?
Yeah, I mean, I'm still back on E. Participant may terminate representation anytime. So he doesn't like the way the hearing's going, so he says, I'm terminating my representative. I don't need anybody's approval.
But I think with the "and," it would require the responsible agency official's approval,
No, I'm
as I'm reading it.
I'm an E.
Ah,
Yeah, I think we should delete E.
people comfortable with deleting E?
But then how do you fire your representative?
I don't know, but these are model rules for representatives.
Yeah, I mean, if we don't think we need it, that's fine. The other alternative might be adding the same written consent and approval of the responsible agency official.
I don't know whether that's actually required in certain court cases, but I agree with Bill that these are rules for representatives and not
Okay.
and not for participants.
And D says withdrawal will be allowed upon the participant written consent. So the participant could say, I want to leave him, but it's going to be subject to the approval of the, I suppose, I guess that looks like the representative has to consent too, but I don't know. Anyway, I like getting rid of D.
Good change to the title. Thank you.
I'm sorry, I might be
Mhm.
missing
No,
something, but isn't it a rule about representatives to determine if you're allowed to stay? Like, so if the representative really wants to stay, they're being paid, there's no cause, but the participant just hates them. Under this rule, they can't get out. Even if they're not being paid, the representative just doesn't want to leave, and the agency official doesn't have any good reason to. I mean, there is no mechanism actually here for termination. And I understand the point that it's not a rule about, it's a rule about representatives, but termination is about, if we're gonna sanction them, they should be able to be terminated now. Am I?
Yeah,
It might be that we want sign off because we're in the middle of a proceeding, for institutional reasons, like Bill mentioned. If we're in the middle of a hearing.
yeah, I can only speak for the IRS. At any point, the taxpayer can terminate their representative. They do not have to ask for permission from the Internal Revenue Service.
Yep. Would that be in the middle of a hearing?
Yep. They just withdraw their power of attorney to the representative.
Yeah. Well, we do have as part of the mandatory withdrawal discharge of the representative. In A. So that's where 1.16 deals with it.
I would still think we might want "and termination" out of the title, though, because this isn't really talking about the process or rules for discharge or termination.
But so that's sort of, but that goes to my, but shouldn't it? If we're doing qualifications, and I understand they're not exactly the same, but the qualification to represent would seem to me to be the photographic negative of the grounds for termination. We mention think we mentioned something in the qualification section. I was looking for it. I can't imagine a scenario where the rules would not permit some version of termination.
Would it belong, so right now we're doing conduct. It seems like perhaps termination belongs somewhere else?
That's, yeah, fair enough.
I think this next section, E, if we move termination somewhere else, might belong with that. But I'm not sure.
So on second review, isn't this duplicative of 301 paragraph E, which also talks about solicitation?
Yeah, I think Lou just put it in two places just to encourage us to think about which is better. Is that right?
I don't know if I did it on purpose, but that's why it's there. I was moving it around so much. I left it there by accident, or I tried to inspire exactly Stephanie's comment. I don't remember. But I know I was going back and forth in my mind, so I guess more is better than less.
I mean, this does not seem like the most natural place to me. So whether it stays in 301 or somewhere else, I don't have strong feelings, but I don't think it belongs here.
How about if we cut it from here, put it as a note in 301, and to the extent any of the language wants to be double checked, I feel like it's already in there in 301E.
Mm-hmm.
The 301, the way 301 is written now is pretty direct. So I'm not sure that the language needs to be changed. We were comfortable with it when we looked at it last time. So and I know we're right at the 2-hour point. I'd like to, if people could just talk about the comments in that last rule, if we could finish up this rule, I think that would be really helpful. And we're very appreciative of everybody's time and energy, and some just really great comments that we're getting today. I don't think we had many comments on the comment section. Do our rewrites, or we'll have to change the references?
Well, yeah, you have to make a change, make that to be B. But we also have changed a lot of the substance of what's in the rule, and that that means I'm gonna have to read this closely. I do have a comment in sub 3 of the comment 3, where it says the responsible agency official shall grant the withdrawal upon participants can provide the withdrawal will not have material adverse effect on the proceeding or the participant's interest in the proceeding. You got to get that proceeding. That's one thing. And is that still sub C? No. Yeah, it is C. C. Okay. Yeah. And then D, obligation to refer to the subsection, including any fees owed. And that we eliminated the old D, didn't we? Yeah, we eliminated it. And then with, you go back up again so I can see the rule. In C, withdrawal will also be allowed based on the consent. That in the comment, that might where we put in termination, all right? something to the effect that the participants may terminate the representation with this subject to the approval of the responsible agency official. Noting that that's different from what the IRS does, apparently.
People have any concerns about adding that language? Okay. Any other comments or comments on the comment?
Well, again, I would just say that I have concerns. Okay, so it says may terminate subject to the approval of the, I just think people should have the right to terminate representation without asking the agency's permission.
So I tend to agree. I may be a broken record here and we're past the 2 hours, but for future discussion, if need be, I would include that sentence as in the rule and include a comment about how that approval should be freely given absent some material harm to the participant's interest or something. I'm thinking of like Rule 15 of the Federal Civil Procedure, the amendment rules, sort of the shall be freely granted. This seems to me to be a big sentence at the end of a comment, or even as its own comment, but I'm more than willing to be outvoted.
Well, you could move this now highlighted sentence to be in front of the previous sentence. And then it would be followed by should freely grant subject to. Now, I mean, I just have to take issue with Nina and Lou. I mean, I'm perfectly willing to say that if an agency wants to allow that, then they probably should be able to. But I just can't imagine saying that any adjudication can simply be stopped in its tracks by having the participant, I mean, Donald Trump says, I'm dismissing my lawyer. All right. I need to get a new lawyer, delay the trial.
Well,
But I would presume in those situations, it doesn't mean an automatic continuance. The person then, that may be a separate issue, right? Whether the court allows the proceeding to be interrupted.
well, and this is not just court. This is agencies, and the agency will generally say, well, I'll give you this many days or weeks to get somebody, or 14 days, but
well,
we're going to have
the question is whether they should be forced to.
Well, the taxpayer proceeds pro se in that way. And that, at least in the Internal Revenue Service and even in the United States Tax Court, that's what happens. The proceedings don't necessarily grind to a halt. They go forward with the taxpayer representing themselves, which may be a disaster, but that's the taxpayer's choice.
Then I think that needs, I mean, I'm willing to accept that if that's put in the comment, right? That, and I don't know exactly how to put it. I'd let somebody draft something, but it just seems to me that they don't get the right to a continuance and to delay. If they want to go pro se, okay, that's up to them. But otherwise, they don't have an absolute right to get rid of the representative.
But
So it
something
should be freely granted, provided it doesn't cause undue delay in the proceeding.
But I think it's something different. I think it's another sentence that says termination of a representative will not necessarily impact the deadlines in the proceeding or
The efficient conduct of the proceeding.
because I think the idea is they can terminate them, but that doesn't mean that the proceeding is going to change course.
Right.
Right, I think that's what's key. And actually saying that, if someone were reading this would say, okay, I have to think about whether I'm going to terminate somebody or not.
And I would change it to will not necessarily, should not impact the efficient conduct of the proceeding.
That also allows the agency official or the judge to decide that getting another representative will improve the efficient conduct of the proceeding.
Yep.
You know, if you have such a toxic relationship between the rep and the individual participant.
And so the next sentence would be, should freely grant withdrawal or termination. Withdrawal or termination will not have a materially adverse impact, provided the withdrawal or termination. The next line. Am I right about that? No, there too. There also. Right, you're just copying, sorry. That's my fault. I think it needs to go in both places. Withdrawal or termination upon the participant's consent, provided the withdrawal or termination. There it is. I will stop now.
Are people
Well,
comfortable
I'm
with
now
that
wondering
language?
again whether maybe that should be back in the rule. Those last couple of sentences.
We could really start at participants may terminate the representation and move that up to the rule. Would it be the last one or
Yeah, I
new
think
one?
so. I think E, the new E.
Well, you could just restore the former D and change the language at the end. Yeah.
And now everything else is the comment to E.
I think starting at termination, right? Yeah, that to the end is
But
the comment.
Yeah, well, yes, except we have some of that, but is relevant to withdrawal too. It's basically duplicative language for withdrawal in comment 3 and termination in comment 4. Oh, that works. And then we need to do that first sentence down there too, right? Or we could just put C, make comment 3 to subsection C and E and undo the delete.
Excellent. Do we have any other comments or thoughts on 307 before we conclude?
I have one tiny comment.
Okay.
In the new section, shouldn't it be a participant may terminate? I'll be content with my
Mhm.
value add here.
Yeah. This has been just wonderful. I really appreciate everyone's contributions. And we kept you over time. So I want to let you all go. We will schedule another meeting. We will start with proposed Rule 308 on fees. And I anticipate we'll send out a final notice, but I anticipate our next meeting will be September 7th at 2 p.m. So I hope
September
many of you
7th,
can,
yeah.
yeah, I hope many of you can make it. And if you cannot, please feel free to email your comments ahead of time. It's really valuable to us. Everybody's provided a lot of wonderful information, and please don't hesitate to reach out at any point. But that's our tentative next meeting date is September 7th at 2 p.m. All right. Well, I hope everybody enjoys the rest of your day. Thank you so much. And I hope that we'll be able to see many of you at our next meeting.
Thank you, Erin.
Thanks, Aaron.
Thanks so much,
Thank you.
Aaron. Thank
And
you,
thanks,
everyone.
Lou.
Thank you.